Hello, my name is David Nash. I'm the coordinator for the Legal One program and the host for Legal One School Law TV. Welcome to this episode of Legal One School Law TV. Today we're going to be focusing on New Jersey's new tenure and evaluation law, known as TEACHNJ. The new law includes major changes in how we address the attainment of tenure, in how we address the filing of tenure charges, and the rights that individuals have when tenure charges are filed. We're going to be focusing today on certain aspects of TEACHNJ, New Jersey's new tenure law. We're going to look at the issues that are within an arbitrator's purview in deciding tenure charges for inefficiency. This is a major change from the prior law. Under the prior law, arbitrators were not involved in making those decisions. They were made by administrative law judges and then subject to review by the Commissioner of Education. We're going to be reviewing some of the key elements that arbitrators are allowed to consider in addressing tenure charges for inefficiency. This includes claims that an individual may have been the subject of discrimination and that the tenure charges may not be justified. Individuals who are subject to tenure charges also have the right to bring a claim that perhaps they're the victim of a retaliation claim. Perhaps they blew the whistle on certain inappropriate actions going on in the school district, and now they're being retaliated against for having done that. It's very important that school districts and all those involved in bringing tenure charges understand all of the potential claims that an individual can bring when they are subject to tenure charges as a defense to those charges. We will be reviewing all of those claims that are potentially brought under TEACHNJ. We will be reviewing strategies for how school districts should be preparing for and defending cases when they are brought, how we address tenure charges. We'll be reviewing strategies for minimizing liability under TEACHNJ. We also have with us today a guest who is very knowledgeable on all of these issues, Perry Ladwa. Perry is a partner in the law firm of Adams, Stern, Gutierrez, and Ladwa, and will be spending time with us talking about some of the practical aspects of the law and some of the lessons that we're learning from initial decisions that have come down from arbitrators who are now deciding tenure cases. Before we interview Perry Ladwa, we are going to provide a little bit of background information for you on TEACHNJ. It's important that we understand the new law and understand how the law came into effect and some of the major changes that are included. The new law was signed by the governor on August 6, 2012. It includes major changes throughout the tenure process. This includes how individuals attain tenure, the timelines and the standards that are involved in tenure attainment, how we evaluate staff. School districts throughout the state are going through fundamental changes in developing staff evaluation procedures and ensuring that they have consistent rubrics for doing evaluations and that those rubrics are approved by the state of New Jersey. There are new standards for bringing tenure charges for inefficiency. Those standards lay out specifically what school districts must do prior to bringing a tenure charge for inefficiency. Individuals who are subject to tenure charges for inefficiency have procedural and substantive due process rights. When those cases are brought, those rights are different in some respects from the rights that we had under the prior law. Under the new law, all certificated staff members must receive a rating of either highly effective, effective, ineffective, or partially effective each year as part of their annual summative evaluation. So that is a major set of changes from the old law. The new law also includes a specific requirement whenever an individual employee receives a negative evaluation. If the employee is rated as ineffective or partially effective, school districts are now required to put in place a corrective action plan. That corrective action plan must be developed by the teaching staff member in collaboration with the supervisor who is working with that individual. It must include specific timelines for corrective action, specific responsibilities for the individual teacher or teaching staff member who is subject to the corrective action plan, specific responsibilities that the district must comply with as well, and supports that the district is going to provide in order to help that teaching staff member improve and address any areas of deficiency. The new law is critical as far as corrective action plans. If school districts do not abide by their responsibilities, they are unlikely to be successful when tenure charges for inefficiency are brought. The new law eliminates the requirement that we had under the prior law. The prior law required a 90-day improvement plan before tenure charges for inefficiency could move forward against an individual. That provision is no longer in place under the new law. Under the new law, a superintendent must file tenure charges of inefficiency whenever an employee is rated ineffective or partially effective in 1 year, and then the following year is rated ineffective. Under the new law, a superintendent may file tenure charges of inefficiency if an individual is rated partially effective 2 years in a row, or if they're ineffective 1 year and partially effective in year 2. Very importantly, if a superintendent chooses not to file tenure charges for inefficiency when somebody is rated partially effective 2 years in a row, they now have a requirement to put in writing to the Board of Education the exceptional circumstances justifying why this individual deserves an additional year before tenure charges for inefficiency will be brought. This is a major change in the process for superintendents and for school districts in dealing with tenure charges. The new law has major changes in due process. As we mentioned, cases are now going to be considered by arbitrators rather than administrative law judges. The procedures involved in arbitration cases vary from what we have had in prior administrative law hearings. There are very strict limits on discovery in new cases, very tight timelines for how we handle tenure cases, and a limited scope of review and appeal as far as arbitrator decisions. Under the new law, arbitrators are appointed by the Commissioner of Education to hear specific cases. The state of New Jersey has a list of 25 permanent arbitrators, including representatives chosen by various associations, including the New Jersey Principals and Supervisors Association. Arbitrators are randomly assigned to cases by the Commissioner. Under the new law, a hearing must be held within 45 days of the assignment of a case. The cost of the arbitrator is borne by the state of New Jersey, but the presumption is that a tenure hearing will last no more than 6 days. In addition, there are limits on discovery. There are no depositions permitted in tenure charge cases, and interrogatories are limited to 25. So we're only allowed to ask 25 questions of the other side in preparing for tenure cases for inefficiency. Finally, a decision must happen within 45 days of a hearing. The decisions of the arbitrator are not appealable to the Commissioner. There's very limited judicial review when it comes to these decisions. As far as the timelines, arbitrators can only extend the timelines for how long it takes to hear a tenure case with special approval from the Commissioner of Education. The Commissioner has broad authority and may remove an arbitrator if that arbitrator is not adhering to the required timelines. If this were to occur, there would be a new arbitrator and a new hearing that would have to be held in a particular case. There are certain issues that are within an arbitrator's purview. So an arbitrator in a tenure case is only allowed to consider certain specific factors in deciding whether or not the tenure charges are justified. For example, an arbitrator can consider if the evaluation failed to adhere substantially to the district's evaluation process. Every district is required to have a specific evaluation process approved by the state of New Jersey that they're adopting, and they must adhere to that process. An arbitrator can consider if a district failed to follow and put in place a corrective action plan. An arbitrator can consider if there is some mistake of fact in the evaluation, something that factually is simply incorrect regarding that employee's performance. An arbitrator is allowed to consider, and this is a critical aspect that we're going to spend time talking about today, an arbitrator is allowed to consider if the tenure charges for inefficiency are actually motivated by some illegal motive. For example, are they motivated by the political affiliation of the teaching staff member? Are they motivated by issues of nepotism, of union activity, of discrimination, or perhaps whistleblowing or some other illegal motive? Certainly, if an individual is able to prove that the tenure charges against them are really motivated by one of these illegal reasons, they're going to be able to prevail in defending against those tenure charges. An arbitrator can also consider if the district's actions are completely arbitrary and capricious and there is no rational basis to support the charges. Importantly, an arbitrator cannot second guess or reconsider the evaluator's judgment. So when an evaluator says that an employee is not effective at classroom management and handling discipline issues in the classroom, this new statute says that the arbitrator should not be second-guessing those judgments. However, as we're going to see through our discussion today, there are ways that arbitrators will be allowed to consider the evaluations of individuals and whether or not they're being treated fairly. Certainly, if an employee brings a claim that they are the victim of discrimination, it's going to raise important issues for an arbitrator to consider. So we want you to understand the elements involved in a discrimination claim, because it's likely under the new law that we are going to have a number of employees raising the issue of discrimination when they're subject to tenure charges. In order for someone to bring a claim of discrimination under state or federal law, they must meet certain requirements. One of those requirements is that the person is a member of a protected class. Under state and federal law, we have a wide range of protected classes, including age, race, ethnicity, gender, sexual orientation, disability. Under these and other categories, a person has protections and cannot be discriminated against. An employee, in order to bring a discrimination claim, must also prove that they have suffered some sort of an adverse employment action. Obviously, the filing of tenure charges against an individual would qualify as an adverse employment action. And then the major challenge is to prove that there is a nexus, that there is a connection between the adverse employment action and discrimination. The employee has certain ways that they're allowed to try to prove that connection. The employer has a requirement, if a discrimination claim is raised, to provide some sort of a legitimate, non-discriminatory reason for their action. Then the employee has the ability to show that whatever reason the employer comes up with is actually a pretext. And the true reason that they're being subject to this adverse action, including possibly tenure charges, is that the person is being victimized because of discrimination. The employer then has a chance to show that even if there was some illegal motive, the district would have taken the same action absent that illegal motive. In order to help understand how a discrimination claim would work under the new law, we want to provide you with just one example. This is a case from 1998, Greenberg versus the Camden County Vocational and Technical Schools. And in this case, we had a non-tenured teacher, 48 years old, happened to be Jewish. This non-tenured teacher was not renewed by the school district. The individual claimed that the reason they were not renewed was because of discrimination. The individual claimed that they were the victim of discrimination based on age and religion. The district certainly had evidence in this case of poor performance. One example was that this was a teacher who, when she was being observed, was supposed to be teaching Hamlet. The teacher, on the day of the observation, was clearly not prepared, had not bothered to read Hamlet recently, and was unable to effectively teach that lesson. So that was a pretty powerful example of poor teaching performance. Nevertheless, the teacher brought a claim of age discrimination and discrimination based on religion. The religious discrimination claim was dismissed. The teacher simply did not have strong evidence to support that claim. But importantly, the teacher did gather statistical evidence to show that younger teachers nearly always receive tenure, and that older teachers hired by the district almost never receive tenure. The teacher claimed that her poor performance was, the alleged poor performance was a pretext for the district's true motive, which was discrimination. The teacher was able to gather evidence that showed that perhaps she was being held to a higher standard than other teachers who received poor evaluations, and in some respects, evaluations that were worse than hers, who still received tenure. Given all of these elements that the teacher was able to show, her case actually was allowed to move forward. The district tried to have the case dismissed, said that this was so clearly without merit that a jury should never be allowed to consider this case. And the court ultimately said no, this individual is raising legitimate claims that may be viable and should be considered by a jury. The court denied the district's motion to dismiss the case. This case provides a powerful example of the potential for a school district to face legal liability and potential claims that could arise related to the new tenure and evaluation law. If we think about this case, it involved a non-tenured teacher. As we know, non-tenured teachers have limited rights, have limited rights to appeal their non-renewal. But even a non-tenured teacher has the right not to be subject to discrimination. In this case, there was an indication of a claim that this person was being held to a different standard, was being discriminated against potentially because of her age. This case shows the critical need as we move forward under the new tenure law for all school districts to be consistent in how they evaluate their staff. Certainly if a non-tenured teacher is able to prevail in a case like this, we have the potential for tenured teachers who have even greater due process rights to prevail if districts are not consistent in how they do their evaluations. Another set of claims that potentially could arise under TEACHNJ, the new tenure law, are claims that an individual was subject to retaliation. We commonly refer to this as whistleblowing claims. You may have an individual who reports a potential violation of law regarding something that's a matter of public concern. For example, a school district employee might think that a district is not properly handling a health or safety issue. Or the individual might raise a claim that there is some sort of corruption that's going on in the district, or some sort of negligence that could lead to injury. And the individual could claim that tenure charges are being brought against them as a form of retaliation for blowing the whistle on an illegal district practice. The challenge that the individual would have in a case like this is proving the connection between the adverse employment action taken and the fact that they engaged in some sort of whistleblowing activity. We wanted to provide you with an example of a case so that you can see how that connection might be proven in future cases that could arise under the new tenure law. So one example involved a case called Green versus the Jersey City Board of Education. In this case, the teacher brought a claim alleging that there were certain violations of the Conscientious Employee Protection Act, which is New Jersey's whistleblower law. This teacher claimed that she was asked to accept a check for $500 and told to give the money to another teacher who supervised after-school programs. The problem was this other teacher was not properly credentialed and would not have been permitted to supervise that program. So this teacher was pressured to accept this check and give it to the other teacher. The teacher received the check, did not accept it, reported it to the payroll supervisor, sent it back to the Board of Education, and sent a letter detailing the fact that this inappropriate activity was going on. The teacher then claimed that she was subject to a series of retaliatory actions and that she suffered medically as a result. She ended up with severe headaches and out on medical leave. The court, in this case, held that there were a series of adverse employment actions taken against this individual. Even though the individual actions appeared to be relatively minor in some cases, for example, the teacher claimed that if she asked for professional development, she was less likely to get approval than other teachers. If she asked for access to the photocopier of the school district, she was less likely to have access to it. She was assigned to a classroom that was more cramped and less comfortable than some of the other classrooms in that school. Separately, these appear to be minor issues, but the court held, taken together, these minor actions represented a pattern of adverse employment action because this person was the victim of retaliation. The teacher was allowed to file her claim within 1 year of the last act of retaliation because the district was considered to have engaged in a pattern of retaliatory conduct. In this case, the court held that punitive damages could be imposed against the school district. The teacher prevailed, and the final award in this particular case was for $265,000 in compensatory damages and $300,000 in punitive damages against the district. We should note that it is very rare for an individual employee to ever have to pay punitive damages. Those cases are reserved for when the individual employee is actually engaging in willful conduct and harming another individual. But in this case, the school district ended up paying more than $500,000 in damages because the individual was able to prove that they were subject to retaliation for blowing the whistle on the activities of this particular principal. So with that background and with some basic understanding of some issues that might arise under TEACHNJ, we have now set the stage for the discussion that we'll have with Perry Ladwa. Perry is a partner in the firm of Adam Stern, Gutierrez, and Ladwa. He's a very experienced school board attorney. He's a past president of the New Jersey Association of School Attorneys. We'll be discussing with Perry the potential for discrimination and retaliation claims to be used in response to tenure charges for inefficiency, and we'll be discussing some tips for minimizing potential legal liability. Hello, my name is David Nash. I'm the coordinator for the Legal One program and the director of legal education for the Foundation for Educational Administration. Today we're doing the interview segment for the second episode of School Law TV, Legal One's monthly online informational program that talks about the latest developments in school law. Very happy to have with me today Perry Ladwa. Perry is a partner in the law firm of Adams, Stern, Gutierrez, and Ladwa, and the past president of the New Jersey Association of School Attorneys. Perry, thanks for joining me.
Good morning, Dave.
Today we're going to talk about an issue that has garnered a tremendous amount of attention in this state. On August 6, 2012, our governor signed into law TEACHNJ, which really dramatically changes New Jersey's tenure and evaluation system. Let's begin by talking about some of the major differences between the new tenure law and the law that we had in effect prior to that time.
Well, the landscape for teachers did change on August 6, 2012, when the governor signed this bill into law. The NJ Teach Act was a significant departure from the older tenure law, beginning with the timelines for attaining tenure. It used to be 3 years and a day under the old tenure law. Now tenure is attained after 4 years and a day. Prior to the new Teach Act, each district had their own evaluation system. Individual evaluation systems leading to a process for teacher assessment, and if teacher was not performing up to standards, it would move on to a hearing. The new process requires a statewide model. That's a model that's approved by the state for each district, using standards that are set out by the state of ineffective, partially effective, of course, effective and highly effective are the four categories which must be in every evaluation document around the state. The third major process, as I see it, involved where tenure cases go. Tenure cases involve a teacher who is deemed to not be performing up to standard, and that the district is then looking to separate that teacher from employment based on performance or other type of conduct on becoming issues. Those cases used to be transmitted to the Commissioner of Education and subsequently to the Office of Administrative Law for hearing before an administrative law judge. That process was supposed to be an expedited one, but obviously over time, and the law was around for over 100 years, the cases took their time going through the system. There was a desire to make sure there was some expedited process that went along with new tenure cases, and so cases are now brought before an arbitrator. And the new law requires a panel of 25 arbitrators be selected and maintained by the Department of Education, by the Commissioner, and cases are now funneled to those 25 arbitrators. Those are the major differences between the new law and the old law.
So in theory, under the new law, we expect these cases to move more quickly?
I believe that is the theory. There's actually a requirement in the law that the cases be heard basically 45 days from the first date of the hearing, that a decision be rendered. And arbitrators generally are used to working with an expedited time frame. Hearing days will be minimal. In this case, there's a cap to that arbitrators can earn. I think that will have the effect of limiting the number of hearing days you have. But yes, we expect the process to move a little bit quicker under this new process.
And with the new process, the arbitrators are given very specific issues that they're allowed to consider and other issues that they're not allowed to consider. For example, the new law says that really an arbitrator should not be second-guessing an evaluator's judgment when the evaluator is saying this teacher is not very effective. What does that mean in the real world? Does that mean that we're simply going to have these things accepted as a fact whenever someone says a teacher is ineffective?
Well, yeah, the law is very clear that arbitrators cannot second guess an evaluator's determination of that teacher's performance, which makes some sense because the teachers are evaluated by individuals who are certified by the state to supervise and assess their employment.
Sure.
So to have an untrained individual, which is what an arbitrator is, or an uncertified individual, then go through and review or second guess the performance, the law seems to have gotten it right on that point. But the other issues, of course, arbitrators can still consider what ALJs used to be able to consider, which is whether an issue is arbitrary or capricious, or a decision to bring tenure charges was an arbitrary or capricious one, not rooted in any specific reasoning by the school district. They can also certainly, they can consider also whether something is an inappropriate consideration as part of an arbitration decision.
So, for example, if there's an illegal motive that's driving the evaluation.
That's correct. For example, if you have a staff member who's a union official, and a case is brought against that staff member can suggest or bring evidence to support the fact that this decision to move against my employment has everything to do with my role with the union and not necessarily anything I'm doing in the classroom, which is obviously an issue. And we expect many employees to raise issues such as discrimination, whistleblowing, retaliation, to the extent that those issues can be factually supported by things that have happened in the workplace. We expect that to be a continuing part of how employees will try to challenge the decisions to remove them from employment.
So what sort of concerns do we have? Let's say you have a teacher who the principal has some concerns about that person's performance. The teacher also happens to be a union representative, happens to be somebody perhaps who has filed some grievances against the school district. Does that mean that the district might be vulnerable to an anti-union animus claim if the district considers tenure charges for inefficiency?
I believe they would have to contend with that particular assertion. And the way you do it is to make sure that the reasons supporting your decision are bolstered in terms of you can focus on specific performance issues, observations and evaluations, and make sure that you have a series of witnesses, hopefully objective ones, that have documented that performance, because you're going to deal throughout the tenure case with the assertion that this is happening based on based on the employee's union role. But if that school district or that principal is able to show perhaps just detailed assessments supported by the records, supported by maybe more than one representative from the school district to deal with the question of objectivity, I think that's how you go ahead and successfully prosecute one of those cases.
Sure. And certainly the arbitrator could also consider claims of employment discrimination. Somebody says that they're the member of a protected class and they're being singled out and held to a different standard than other folks. Is that possibly a backdoor way to start looking at the evaluator's judgment and looking at how clear and consistent the evaluations are?
Well, the idea of consistency on the part of the school district is always going to be an issue, and will always come up in a case where an employee is suggesting that discriminatory motive is the reason for their employment. And in that scenario, they are in fact comparing themselves to others. Was I treated differently than a teacher who is male, for example? Was I treated differently in terms of other teachers who are perhaps younger? So those issues will come up. And while I think it'll allow the arbitrators to consider those things, they will have to be very careful not to invade the evaluation to confirm whether that issue is really based on the evaluation process itself and or the discriminatory motive that's being asserted.
Sure. And I guess there's some lessons that we can learn. We have a long history of cases that have dealt with employment discrimination and employees trying to prove that they've been the victim of discrimination. I would imagine some of the lessons that we learned from those cases are going to be applied by arbitrators when we're looking at tenure cases to figure out whether there's an illegal motive involved.
Right, and in those instances you're looking for inconsistencies, implausibilities of the employer's reason for its termination decision. The word that's used in the employment context is pretext. Is this happening because of a legitimate business reason, or is this an excuse? Is my assessment and evaluation really an excuse to get rid of me based on the fact that I am part of a union, or I am a woman, or whatever the protected category happens to be? And yes, there has been a long history of those cases being prosecuted in superior court. Now arbitrators, in the context of a truncated hearing setting, will have to deal with many of those issues. And in many instances, those cases play out in trial courts before juries, but now the arbitrator is the fact finder and sole determiner of what will happen with that. So that's a unique environment to have an employment claim be vetted, but that's what's going to happen going forward.
And one of the things that we've seen in past employment discrimination cases where somebody says that they're being held to a different standard and looks at adverse employment actions. It doesn't have to be something as serious as somebody losing their job. I've seen folks make successful claims of employment discrimination when they were transferred to the classroom nobody wanted to be in. Right. They were denied the access to go on a professional development conference that other people were allowed to go to. Right. So some of the adverse actions that can help make a case can be pretty subtle.
I agree, and there's another difference, because in the employment law context, a transfer, for example, is not considered an adverse action under the SEPA law or whistleblowing law. However, in an arbitration context, an arbitrator may consider a transfer to be evidence of a discriminatory motive and may use that to reach a decision involving the fact at hand, which is, should this teacher be removed from employment? So while many of these issues and facts could not technically sustain a claim under the law against discrimination in superior court, I see a situation where it may have a big impact on an arbitration decision, on a tenure decision being heard by an arbitrator.
And the same thing is true certainly with possible retaliation claims. Let's say somebody believes they're blowing the whistle on some sort of illegal practice going on in a school district, and now all of a sudden the person is getting negative evaluations. Right. Certainly an arbitrator would be allowed to consider the timing of that issue, whether there is some link between the poor evaluation and the fact that there was whistleblowing activity going on.
That's correct, and the timing of that is key in many instances, and you do have a series of years in which to decide if you want to move forward with tenure charges. And perhaps the timing of a protected activity on the part of an employee, such as speaking before a board meeting on certain issues or raising a complaint through another supervisor. If the timing of that is you're now assessing that employee and thinking about bringing a tenure case, and many times it's often important to wait, make sure you fully investigate and come to a conclusion as to the employment discrimination claim that's being asserted, assuming it's being asserted internally within the school district, and then go through a process of an evaluation after that's been decided and rely on that. It's just a more prudent approach to dealing with an employment discrimination claim, because in many instances the timing of that is such strong evidence that within weeks of a particular complaint or protected activity, charges are being brought against me. Arbitrators will look strongly on that evidence, and so sometimes the district is in a much better position if they make sure they review, come to a decision as to the claim that's being made, and then move forward with an assessment and perhaps delay their decision to bring those tenure charges, if they have the discretion to do so.
Sure.
There are some instances in which you cannot delay that decision if an employee is performing in an ineffective way for 2 years in a row. This new tenure law mandates that discrimination charges move forward. So in instances where the districts will have discretion, they would be wise to use it to avoid a timing issue.
Sure.
But in instances where they are unable to, because the law says you have to bring these charges, then you definitely are forced to go forward and and see what will occur with that. Although I think your retaliation claim is weakened if there's strong documentation of ineffective performance 2 years in a row.
Well, that's an important point. These cases for tenure charges for inefficiency going forward, we're going to have 2 years of evaluation data where you're rated ineffective or partially effective before you can move forward with those cases. So I would imagine that there's steps school districts should be taking along the way during that 2-year period to make sure they're in the best possible position if they do need to move forward with those tenure charges?
I agree. It starts with making sure that you have a state-approved evaluation model, and once that occurs, then following that evaluative process to the letter of the law. That's an issue we have generally with school districts, is because it's not a centralized employment location setting, meaning different schools tend to veer off on their own and follow different practices. Sure. It's important to make sure that the school district has one consistent process throughout the district, because process issues is where I think many of these cases are going to be won and lost. Did they follow the track of that process? For example, corrective action plans, as an employee is determined to be partially effective or ineffective, are a requirement of this.
Sure.
And it requires not only a corrective action plan, but a process by which the supervisor sits with the employee for post-observation conferences to sit and basically mutually develop that corrective action plan.
Sure.
If that step is missed, this is a step that could violate basically could impact negatively the tenure hearing that's going to happen in a year or two, because the district did not follow those sequence of steps.
And once you have a corrective action plan, that is a legally binding document. So, for example, a school district creates a corrective action plan and says they're going to provide certain supports, they're going to provide certain feedback for that teacher. They need to make sure they live up to their end of the bargain if they want to proceed with tenure charges.
Absolutely. The corrective action plan feature, and the fact that it also requires you to provide teacher supports and staff development to allow the teacher to improve in the areas in which they're being negatively reviewed, is a big part of this. And if those steps aren't there, if you aren't able to document that you provided support or staff development for the teacher in those areas, that's another area where I believe arbitrators will strike down the attempts to remove that employee from employment, and may send the employee back to the district to go through a process of staff development to see if they can actually improve on their performance. Sure. But of course, you've got the timeline issues where if that's happening towards your 4th year, you have an employee who's going to be attaining tenure.
That's right.
If not completely removed.
That's right. And I know one of the other issues that's in the new law is that we have to make sure that we have consistent evaluations from one evaluator to the next. Right. That's easier said than done. As human beings, we all have our own things that we value, areas that we think folks should be excelling in. It's critical that we all get on the same page with whatever model the school district is using and hold folks to the same standard.
Yeah, I agree. That's where I believe superintendents of school districts are under a lot of pressure to make sure that not only is there full understanding of their evaluation tool by all staff and all supervisors throughout their district, but clearly that it's being applied in a consistent way.
Yes.
And that's something we see come up over and over again in tenure cases, which is the teacher being able to effectively assert, this is a process that was followed by my principal, but putting on evidence that this process isn't being followed in any of the other schools in the district. Absolutely. And you have a consistency of application issue, and that process piece is going to be a large factor, since arbitrators can't decide or can't invade the evaluation. They will look at process, they will look at timing, sure. They will look at, illegal factors, illegal motives. Absolutely. For the decision. Those will be their focus.
We have now a little bit of experience with the new law. The new law was signed in August by the governor. We have a small sample of arbitration decisions under the new tenure law. Are there any lessons to be learned from some of the decisions that we've seen come down? Well,
the decisions, and I believe there's about 15 to date, yes. Since the law went into effect on August 6th of 2012, and they're consistent with arbitrator decisions. Some have sustained the district's attempt to remove the employee. Others have returned the teacher to the district with a lesser sanction.
Sure.
So they've gone all over the map. What we do see in the decisions is a struggle by the arbitrators to stay within what I consider to be the limits that have been imposed by the law. In one, the Hawthorne decision, a recent Newark School District decision,
sure.
The arbitrator is literally saying, he's making a conscious attempt in his decision to stay away from invading the evaluative process, but in reviewing many of the other factors in the case, he goes on to to clearly touch on some of those evaluative steps as he's coming to the ultimate decision in that case.
Yes.
And in the other decisions, the process has been a somewhat expedited one in terms of decisions are coming forward a little bit quicker, but it's just not clear what the body of what the ultimate outcome of the arbitrator impact will be at this stage. It's just too few decisions.
Sure.
At this point.
In working, you work with many school districts as a school board attorney. What advice are you giving at this point in time for folks who are just struggling with implementing this new law and making sure that they have in place what they need to have in place if there are tenure charges down the road?
Well, we're at this stage, we're making sure that our districts have their approved models in place. We make sure that they are following the pilot program that's required at this point, so they have essentially a dry run of how this should work when it goes into full implementation in September 2013.
Yes.
And the staffing is a big piece of this. Staffing and fundings. Many people don't realize that your school business administrator can apply for enhanced funding under the law to provide the resources you'll need for this. For example, it requires in many instances more than one evaluation for a tenured teacher, so you'll need, it basically doubles your requirements for
Sure.
evaluations for tenured teachers, so you may need additional staff to be there to complete all these requirements, and certainly multiple, more than 3 for non-tenured teachers. So getting those pieces in place to make sure you assess staff, thoroughly, that you
Yes.
have the number of supervisors you need to follow through on all the processes, and then you're applying them consistently. We've been guiding our districts along that track at this stage.
And doing this well now requires far more observations and evaluations than we were required to do before. So I think that's great advice to make sure that folks have the staffing in place to do this.
Right. And follow a process that's a consistent one.
Yes.
That's so important, and we've emphasized that in our training, and we've emphasized that in our communication to our clients. Make sure that process is consistent, because that's the first assertion that's going to be made, is that you're not following a process consistently in all your schools.
And the new law does include a provision that says the state of New Jersey should provide funding through the Department of Education for any additional costs that are imposed because of this law. So it seems to me there is some opportunity for school districts to seek that additional funding.
Absolutely, absolutely. And they should, because there are a lot of manpower requirements that go along with the law.
Great. Perry, thank you so much for being with me. It is really a great discussion, and hopefully school districts will take the time to really think through how to put this law into effect and do it in a way that helps kids.
It's been a pleasure, Dave.
Thank you very much.